Good morning. Today we are going to analyze one problem question on law of lease. Disclaimer: this video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's start with the problem question. When Sandro retired, he used a lump sum from his pension to buy a small cottage in a sea town in Wales, where he had always wanted to live. Having decided to keep his properties in London, Sandro made the following arrangements. Sandro allowed his nephew, Julius, and Julius' best friend, Karen, to live in his two-bedroom house in Bow. Sandro was relieved that he was going to have people he trusted to take care of his house. Before moving in, Julius and Karen each signed an identical document with Sandro. Each document was headed Residency Agreement. The terms include the following classes. There are four classes. The first one is the resident has a right to live in the house on a monthly basis. Monthly basis is the keyword. Sandro will retain a key. It's another. He want to keep a key with him. Sandro reserve the right to sleep on the sofa bed in the study whenever he is visiting London to visit the theatre or check on the house. And the resident is liable to pay £200 per month to live in the house. A week after moving to Wales, as Andrew emailed Julius, he told him that as he was enjoying living by the sea so much, he would not be making weekend trips to London for the foreseeable future. So the Sandro entered a deed with the Horticulture PLC, and giving it an exclusive use of the plot of the land that Sandro held on license from the London Borough Council. Sandro had used the plant to grow his own produce. A deed provided that Horticulture PLC could stay on the plot for 3 years or until such time as I decide to return to live in London. The second phrase is looking like it's a indefinite duration. Sandro agreed that Colin could have a 2 year legal lease of Sandro, a lock-up garage in East London, or just for him to use for his car repairing business. They agreed that Sandro could terminate the lease by giving Colin a 6 months notice. Sandro and Colin settled on the amount of rent for the garage by following the advice of the local estate agent who regularly takes his car to Colin for maintenance and repair. Sandro did not finalize the grant for Colin's lease before he left for Wales, and he later forgot all about it. Colin was not bothered because he had already moved into the garage and was paying a rent each month in Sandro's bank account. We have to advise Sandro about the legal effect of arrangement he has made with Julius, Karen, Horticulture PLC, and Colin. Arrangements with Julius and Karen. Yeah, first one is the exclusive possession in Street versus Montfort case. The House of Lords established that exclusive possession is a hallmark of a lease. Here, Sandro retained a key and reserved the right to stay, suggesting that Julius and Karen do not have an exclusive possession. This indicates the arrangement is likely a license. A payment of rent, the £200 monthly payments add to the characteristic of the lease. However, the right of possession is crucial, given that Sandro can enter and has retained the control. The arrangement lean towards a license rather than a lease. When it comes to the nature of agreement, the clause allowing the Sandro to sleep on the sofa bed indicates that he maintains a significant degree of control, which reinforces the view that this is a license. If you see the Soma and Hazelhut case, it suggests that supports the idea that the terms of agreement can indicate whether it is a license or a lease. In Bruton versus London Quadrant Housing Trust, this case illustrates that even a non-owner can grant a lease if they provide the necessary rights and exclusivity. When it comes to the heading and terminology, this document is titled Residency Agreement, which suggests a less formal arrangement than a lease. However, the specific clauses indicates a more structured relationship. The right to retain a key, Sandro retention of a key, and the right to stay at the property suggest that he retains a degree of control which can challenge the exclusivity of possession claimed by Julius and Karen. This aspect aligns with Aslam versus Murphy, where the landlord rights undermined the tenant's claim to the exclusive possession. And the right to sleep on the sofa bed, a class 3, explicitly allows a Sandro to occupy the property, further complicating the claims of Julius and Karen to exclusive possession. This suggests a license rather than a lease, as it indicates that they are not granted full control over the premises. Email communication. Sandro's email indicating he won't be visiting London alter the context of the class 3. It could imply that he does not intend to exercise his right to stay, potentially lending credibility to Julius and Karen's claim. However, it does not negate Sandro's retaining rights. The unity of interest, the class 4, which states the residents are liable to pay £200 per month, may not sufficiently establish a unity of interest required for a joint tenancy. The payment could be viewed as a rent or a contribution towards expenses. It's complicating their status. So, to conclude, Julius and Karen likely hold a license to occupy the property rather than lease, means their rights are limited compared to those of a tenant. Arrangement with Horticulture PLC, exclusive use, they suggest a stronger interest than a mere license, as it indicates the company has substantial rights over the land. Terms of use, the arrangement is not for a fixed term but rather contingent on Sandro's return. This could raise issues of uncertainty in terms of a leasehold law, as seen in Lease versus Chandler case, where the lease must have a definite term. In Antonius versus Villiers case, it highlights the importance of formalities in land agreement. Here, the exclusive use suggests a grant for the lease rather than a mere license, especially if the horticulture PLC has a degree of performance Horticulture PLC has a degree of permanence. In section 1 and 2, LPMPA 1989, these sections require that the leases be created in writing and specify the term, which seems to be satisfied here. Duration uncertainty. The deed with Horticulture PLC indicates a potentially uncertain term. The phrase the 3 years or until such time as I decide to return to live in London. This suggests the maximum duration is not fixed, which aligns with Beresford versus Maxwell case regarding the validity of leases with uncertain terms. The intention to create a lease. If the deed is interpreted as creating a lease for life, it may attract section 149.6 of LPA 1925, which addresses the creation of leases that are effectively for life. The intention is critical. Thus, if Sandro intended to retain flexibility, this might influence the legal interpretation. Licensing issue. Since Sandro only holds a license to use a plot, he may not have authority to create a lease in favor of Horticulture PLC. This aligns with the Brunton versus London and Quadron Housing Trust, where a licensee cannot grant a lease. To conclude, the agreement may resemble a license due to its indefinite nature, and it could be argued that it is not a lease due to the lack of certainty of term. However, if Horticulture PLC has exclusive possession and Sandro's ability to revoke is limited, it may be enforceable as a lease. Arrangement with Colin, a creation of lease. The agreement to grant Colin a lease is valid under the property law as it outlined the term 2 years and involves rent. Non-finalization of grant. The fact that Sandro did not finalize the lease before moving does not negate its existence. Colin's occupation and payment of rent indicate the acceptance of the lease terms as per the principles in Bruton versus Landon and Quadrant Housing Trust, where the court recognized a non-proprietary lease. Section 54.2 of LPA 1925, this act allows for the lease of less than 3 years to be created without a deed, indicating that Colleen may have a valid lease even if Sandro forgot to finalize it. Written agreement. If there is a written agreement, it could create an equitable lease and Wales versus landlord case, which would be enforceable even if the formalities were not completed. Oral agreement. If the agreement was oral, the Collins occupation, the payment of rent, could imply an implied periodic tenancy under the section 54.2 of LPA 1925. The monthly payments and Collins established residency support this interpretation. Notice period. A notice period for termination would depends on whether the agreement is deemed written or oral. An oral agreement might require a shorter notice period, affecting a Sandro's ability to terminate effectively. In order to conclude, Colin likely has a valid lease for the garage, and Sandro's failure to finalize it does not affect Colin's right as a tenant. Hence, conclude, Colin likely has a valid lease for the garage, and Sandro's failure to finalize it does not affect the Colin's right as a tenant. When it comes to Julius and Karen, likely hold a license due to Sandro's retained control and lack of exclusive possession. Horticulture PLC, it's likely a license due to uncertain terms, but could be treated as a lease depending on the extent of the control and the possession granted. Colin has a valid lease for the garage despite Sandro's failure to finalize the grant. So, Sandro should consider formalizing the agreement, especially with Horticulture PLC, to clarify rights and expectations. Thank you.